I have no faith in state governments defending liberty, and without a definition of individual rights, the states leave nothing to the people. States can and have been just as bad as the federal government, and virtually all states are currently heading in the direction of more state power, not less, despite or in spite of a few token non-binding resolutions passed to pacify conservatives. Now you notice that some 15 or 20 states this year passed a 10th Amendment resolution. And I know a lot of you feel very strongly that this is a step in the right direction. It is, but it's a very small baby step because if you will notice, the state of Utah was not in that list. Why did not the state of Utah pass a 10th Amendment resolution? Because they did so 10 years ago. Can any of you tell me one single time within the past 10 years that the state government of Utah has stood up to federal law and said, we won't comply because of the 10th Amendment? They have not. So what good is it to pass non-binding resolutions praising the 10th Amendment if you have no intention of following it up with contesting federal law? I suggest to you that it's meant only to pacify conservatives, and they're very willing to do that. Conservatives do labor under the notion that a state government is easier to influence than the federal. It is partially true, but the advantage is only very slight. In practice, state governments are also a constant threat to liberty and must be bound down by constitutional claims. Do you realize that it's perfectly legal for states, as Utah has done, to pass a welfare benefits bill? And they did so starting out with health care for children. Do you know that? That's still on the books today. The state of government does welfare spending to provide health care for children. And this is in a state that pretends to obey the original intent of the Constitution. But it's not against the Constitution because the Constitution really only prohibits the federal government by those. So I have no real confidence in states to do that because they're politicians just like the federal level. They know that they can pander to people to buy votes. In addition, the neo-Republican authors of the Pledge to America continue to use the phony war on terror to justify continued foreign intervention without a declaration of war, which is hardly constitutional. The founders were uniformly against federal or foreign wars and foreign entanglements. Today they keep telling us, and Americans keep repeating, the same old propaganda line that our troops are out there defending our liberties. They are doing no such thing, even though, I will say, there are many good troops that actually believe that we are doing so. So I'm not faulting those that falsely believe. I believe, though, that they have succumbed to government propaganda. In reality, our troops are unwittingly working towards our goals, our leaders' goals of creating conflict in the world to justify an eventual new world order, an order that undermines the Constitution and national sovereignty. When will we wake up, ladies and gentlemen, and quit being used? When will we start thinking with our minds and our spirit instead of being duped by mere patriotic emotions? What conservatives must remember is that it is far more important to look at the people writing this pledge than what they say. Wolves in sheep's clothing are expert liars. These are the same establishment operatives that gave us Newt Gingrich, who betrayed us. Remember the contract with America? What did Newt Gingrich do? The first thing he did when he got into Congress and became Speaker of the House, he passed NAFTA and GATT, two planks of the New World Order on a regional level. And they gave us George W. Bush, that false conservative puppet, a leftist actually, unleashed another firestorm this week when he actually talked about whether or not it was true that Bush had said, stop throwing the Constitution in my face, it's just a blankety-blank piece of paper. He said, I got a couple of calls asking if I could verify this quote. I'm sorry, those were my words. I got some calls asking if I could verify the quote, and I can't personally. As I told my callers, I'm not on the receiving end of any purposeful leaks from government sources, but others are. And that's because people in the White House are not people who look towards me as a legitimate source that they want to talk to. People in the White House are establishment Republicans, and I'm viewed as the enemy. But others are looked upon as friendly to them, mostly leftists, like Doug Thompson. He's one of them. because he's both on the left and he's anti-Bush, if they wanted to criticize, because, you know, even the Bush administration hired liberals, and they were all too eager to tell what was going on in the White House. That's how we found out that when he was holding the weekly prayer breakfast on a Friday morning with various controlled ministers, Protestant, evangelical, usually well-heeled ministers, how he would bear witness to them about his commitment to Christ, and yet when they had leave, they would all sit around and slap each other on the back and get back to their four-letter words of the worst variety that you're going to talk about, how they'd snookered those pastors. And that got leaked out to people like Capitol Hill Blues. Well, Thompson says he's been getting a steady stream of leaks from the Republican leaders inside the White House recounting Bush's failing emotional stability and increasingly violent rages using every four-letter word imaginable. This latest outburst about the Constitution was more than just confirmation that Bush was a foul-mouthed pretender of a Christian. And then he said, what's really disturbing, of course, that there were no consequences for that. Here's a person, a president of the United States, who has sworn an oath to the Constitution and yet calls it a blankety-blank piece of paper. That's one of the reasons, ladies and gentlemen, why the Constitution is dead. When the President of the United States can violate his oath with impunity, with no punishment, with no threat. There wasn't a single congressman who even thought about bringing him up for impeachment over demeaning the Constitution. Now, government disregard for the Constitution gets in the way of a lot of things, and Doug Thompson, once again of Capitol Hill Blues, said, Bush is not the first president to consider the Constitution an expendable document, and he won't be the last. Most presidents have complained that the Constitution gets in their way. Presidents, by the way, look for ways to skirt the law when the law gets in the way of their agendas. But then Thompson gets squishy liberal on us. He says, if we impeached every president who disregarded the Constitution and didn't suit his purpose, we'd probably have to try just about every president in the last 50 years. Not true. For one thing, we have had some, like Andrew Jackson, who were very loyal to the document. Second, if we had in times past impeached a few presidents for violating their oath, others might have shown a little more respect for the Constitution. But in point of fact, no one has been impeached for violating the Constitution per se, and never will. That's reason number two. The Constitution is dead. If there is no enforcement, there is no law. If there is no punishment, there is no law. The authors of the pledge advocate the ideals of social democrats rather than true constitutionalists, which is dangerous. Listen to this quote. We make this pledge bearing true faith and allegiance to, you would expect the Constitution, right? The will of the people we represent. People love to hear that, but nobody can make that promise to represent all people, nor should they. Government should represent the fundamental rights of people correctly defined, but not the people's will, unless that will is consistent with fundamental rights. In the founders' view, the popular will must always be bound down by the chains of the Constitution. When our leaders pander to the popular will, we have populism, not constitutionalism, that carefully restricts lawmaking power to the defense of fundamental rights. Now, it's especially bad when conservatives themselves pander to populism and promote entitlements like this pledge does, as past governors in Utah have done, for it corrupts our own constituency and convinces them that a little social democracy isn't so bad as long as it's local. How many times have you heard, as long as it's local children's insurance, we can control that, we can handle it. But you can't. It's called an unlimited extension of lawmaking power. It's a principle in law that people don't often understand. It's like seatbelt laws. People tend to think about whether or not it's good or bad to have seatbelts. That's not the issue in law. The issue is whether or not you give power to determine what is safe for you. If you give the government the power to determine what is safe for you, you've given them the power to have an unlimited extension of lawmaking power into your lives, because everything about your life involves safety. So you can't let government get down that road, no matter how beneficial you think seatbelts are, or motorcycle helmets, or health insurance. You don't give government the power to mandate those things. And conservatives have to understand that, because it's not in the Constitution. It's a principle that has to be derived from an understanding of fundamental rights. That kind of thinking, even if People don't realize that socialism is what deceived conservatives into becoming unthinking supporters of public education, even though it is clear that public education is a violation of the property rights of those who object to that education, who don't want to attend it, and who have to pay twice for sending the children to public schools or for homeschooling. Now, that's one of the sad things, ladies and gentlemen, is that there isn't a single conservative politician in the state of Utah that could get elected under the platform that I will privatize all public schools. Do you understand that? And that's one of the essential principles of liberty, that the government shall not have the power to dictate what you shall be educated at. And I will cover that in another section. But that's what shows you how difficult it is for people who take a true constitutional stand cannot, in fact, get elected unless they pander to certain entitlements. And even conservatives have been corrupted by the entitlement of public education. And why is it an entitlement? Because you pay taxes for education, so you say, we can participate in it. It's not a violation of anybody's rights, but it is. Because the only reason you have those big, fat, expensive schools with all those computers and huge gymnasiums and huge stages is because they're taking my money, not just the people's taxes who use the schools. They're taking everyone else's money, retired and otherwise, who have never been part of it, who object to them, to have enough money to build that. And they don't want to give up that taxing power. In fact, that's the key to understanding why we have the raging controversy of school prayer in public schools. It wouldn't exist if you had free choice in education and you could take your money where you wanted to educate. Because if you wanted to pray in schools, you pick a private school or even any kind of school. And it's all right for a government to have cooperative schools as a co-op. There's nothing wrong with that as long as the participants pay. It's only wrong when you have mandatory education at a public school and you have mandatory tax participation of all people, whether they use it or not. And it is not enough to say that it's in the public good that we have, that everybody pay for private schooling or public schooling. It's in the public good that everybody will be well fed and healthy. Does that mean that we can mandate that you have to pay for everybody's food? We know where that leads. Education is a benefit, just like food, just like health. It needs to be paid for by the individual so that there are incentives to correct and so that there is preservation of choice, because there's choice involved in all of those things. Another reason the Constitution is dead is because we have controlled judges. I'm going to give you an example of the trial judge, William Hoveler, at the trial of Manuel Noriega. You remember Noriega, dictator of Panama, actually elected, but still acted like a dictator. He was a thug. Well, he was taken down in the invasion of Panama by the United States government and put on trial for drug trafficking, wasn't he? At his trial, the government stipulated, meaning that they agreed with the defense, that Noriega had received approximately $320,000 from the United States Army and the Central Intelligence Agency. They stipulated that because Noriega's defense was that, yes, I was guilty of drug trafficking, but I was working as an agent for the CIA in their drug transport program. Now, in a public trial in the United States, do you think the United States government is going to allow a defendant to defend himself by exposing the CIA role in the drug trafficking business? Not on your life. Noriega insisted, in fact, that the actual figure approached $10 million. And that also corroborated the witnesses that were in a helicopter flying during the Iran drug Contra time when there were several high government officials in the Clinton, or before the Clinton administration. This was during the, even during Reagan and Bush eras, where the government of the United States was trading arms for terrorism in Iran and financing it through drug trade in the Iran-Contra controversy in Honduras. And they were in a helicopter, these government officials, talking about how Governor Bill Clinton was taking a bigger cut of the drug trade going through the state of Arkansas. And they didn't realize when they were discussing this on the intercom in the helicopter that it had an open mic to the pilots. These were military pilots flying them around, and they heard this conversation about Bill Clinton taking $1 million a year and laundering it through Mr. Stevens' state bond fund. Well, these became whistleblowers, and the government had to shut them down and threaten their life. There was another whistleblower who revealed that Manuel Noriega, the reason that he was taken down is because he was also getting $1 million a year cut. He began to take more than that. That's why his total take from the CIA was approaching $10 million, and Noriega claimed in the trial that he should be allowed to disclose the tasks and the duties that he had with the CIA concerning that drug operation. The district court under Judge Hobler held that the information, and I quote, about the content of the discrete operations in which Noriega had engaged in exchange for the alleged payments was irrelevant to his defense. Now, when did you hear that in the press? You never saw that in the press, did you? That a judge ruled that that which was key to his defense, the fact that he was working for the United States government, was irrelevant to his defense, that black was white. He appealed the ruling to the 11th Circuit Court of Appeals. Here's what the Circuit Court of Appeals says. They agreed with Noriega. So what do you think they're going to do? Instruct the judge to retry, right? No, sir. Our review leads us to conclude that the information regarding the purposes for which the United States previously paid Noriega potentially has some probative value. Notice how they're just giving him just a little bit without saying what it should have said, that this is the key to his defense and should be allowed. Thus, the district court may have overstated the case when it, not that they violated his rights, but just overstated the case when it declared evidence of the purposes for which the United States allegedly paid Noriega wholly irrelevant. They're saying it's not wholly irrelevant. However, the Court of Appeals refused to set aside the verdict because it felt that the, quote, potentially probative value of this material was negligible. Incredible. Now, you see, they're not giving anybody any proofs of a direct conspiracy. They're giving a squishy legal opinion. And without ever telling you or demanding the court allow the actual details of the evidence to be put into open court, nobody can judge on whether or not this probative value is of relative marginal value or whether it's essential. Do you understand what I'm saying? This is not clear-cut. I know it's clear-cut. I know what they're up to. But it takes a lot of time to convince people that the judges are corrupt. And these are examples. I'll give you another one. Marcia Cook was the notorious Florida district judge that made the incredible ruling that 3.5 years in jail did not count as a violation of the Constitution's speedy trial provision. Do you understand that? Right there in one of the Bill of Rights. The right to a speedy trial shall not be infringed. If you're put in prison for 3.5 years and never given a trial, don't you think that your speedy trial provision would be violated? Well, I think so. But she said that simply because Jose Padilla, an American citizen, of course he was on a trumped-up trial of terrorism, had not been accused of a crime, that the speedy trial provision didn't apply. That means, in other words, that the speedy trial provision, that clock doesn't start ticking until they accuse you of a crime, which means that habeas corpus doesn't have any application in law anymore at all. What is habeas corpus? It means bring forth the body. They put you in jail, they throw you in prison, they throw away the key, and you have the right to go to a judge and say, I demand habeas corpus on Joel Skousen, who's disappeared. Bring forth the body, bring forth the person, and tell us why you're holding him. And now the government's claiming we don't have to tell anything until we charge him with a crime, and we don't have to charge him with a crime, we can hold them indefinitely. That's why the Constitution is dead. It's not because they do this every day. It's because they can do it with impunity. And no one moved to impeach Judge Marcia Clark on this gross violation of legal process. And not even conservative constitutionals did. I have many friends, subscribers to my World Affairs Brief, who are top attorneys in the conservative, and I asked them, why didn't you move to the District Court of Appeals that she be impeached for violating the constitutional rights of the speedy trial? And they said the judges would sanction us if we did that. They would call it a frivolous suit against government. And I'll show you other examples where this has been done. There were accusations that the Bush administration went judge shopping. Professor Frumkin claims that he noted the government specifically selected Judge Marcia Cook by adding Padilla to a superseding indictment, which forced a change in venue. Now, what that means is you take additional indictment in a place that they have a friendly judge, Marcia Clark, and it forces the case then, or at least it allows the case to be taken over by that judge. That's called judge shopping. Now, Attorney David Marcus objects to classifying Judge Cook as a yes woman to the feds, or that the feds were judge shopping, and here's his evidence. He asserts, perhaps the Department of Justice looked at Judge Cook's resume and saw that she was a Bush appointee and a former U.S. attorney and thought that she would be a pushover for the feds. Judge Cook, to put it in Chief Justice Roberts' words, calls a strike and a ball, and does not and will not be pushed around by the government. She's known in the community as a fair judge who listens carefully to both sides and calls it right down the middle. She is well liked by criminal and defense attorneys alike. Now, doesn't that sound like good evidence that this is somebody who is going to be a fair judge and that can't be accused of being a shill for the government? I attest to you that this is not good evidence. But it does show how the government carefully evades showing their controlling hand with judges. Control judges are very careful to act the role of the model judge most of the time, helping establish a deceptively good reputation. They work harder than most to avoid the appearance of ruling for the government, and the government is smart enough not to use the same judge many times in succession in order to protect those that they control. Now, this is how sophisticated it gets. This is how they deny us proof. They don't have the same judge over and over ruling for the government so that it become obviously declared as a shill. Now, the establishment even has judges that pretend to be on our side. Judge Royce Lambert, for example, is a good example of a controlled judge playing to our side. This key judge in the District of Columbia, which is full of liberal judges, heard most of the cases brought by Judicial Watch against the government. Judicial Watch is a conservative, constitutional, pro-legal organization that has been done very, very good work over the years. He would almost always rule against the government and publicly lambast government attorneys in court when they lied to him. He was naively viewed as the one great conservative jurist in D.C., and after years of haranguing government lawyers and officials, I noted that he never actually brought any sanctions against government officials, even when they were held in contempt of court. Not one government official ever served time under Judge Lambert's sanctions. It was all a show so conservatives would think that he was favorable to constitutional causes. Another telling point was that Judge Lambert was appointed to the top-secret FISA court, which covers for a government illegal surveillance by giving out a few warrants under the color of legitimacy. Only insiders are allowed on that bench. That's the top secret court which deals with warrants for illegal terrorism and illegal surveillance. In fact, what's interesting about the FISA court is that the government uses illegal surveillance to get the evidence, to bring to court, to get the judge to authorize them to be legal. Now, if I were on the FISA court, I would say, what's the source of the evidence you're giving me as backup for this warrant? Well, it's an illegal wiretap. Don't come to me with illegal wiretaps. Come to me with actual, adjudicable evidence, and then I'll judge on it. But that's what the FISA court does, and that's how part of the reason our government has control of the courts is to make sure that they can rule in accordance with the Constitution when it is convenient. But when it gets in the way of the hidden agenda of the secret combinations that rule our government, they always cover up and rule according to the phone call in the night. Now, there's no enforcement for outright violations. Let me give you an example here. In fact, they cover up for these things. Ron Paul, as you know, is a great champion of liberty. And during the Iraq War, he was very, very upset that the government continued to refuse to issue a declaration of war on Iraq, that they wanted to use the War Powers Act, which gives the government the power to go to war without a declaration of war, which is actually an unconstitutional act, should have been ruled unconstitutional years ago. But in committee, of which Ron Paul was a member, he suggested to the committee that an official declaration would be war against Iraq. Even though he said openly in the committee, I'm against it, I'll vote against it, but we need to follow the Constitution here, gentlemen, and have a vote on a declaration of war in Iraq. He said, the proposed resolution on the use of force mentions the United Nations 25 times. It does not mention the Constitution once. I do not look to the UN to find the authority for this sovereign nation to defend herself. I look to the Constitution. And then he quoted Article 1, Section 6, which gives the Congress, and only Congress, the authority to declare war, not the President. It was after this that the chair, Representative Henry Hyde, a Republican from Illinois, stated that the declaring war is anachronistic. It isn't done anymore. It was a jaw-dropping admission. But there was more. The chair went on to say that the Constitution has been overtaken by events, by time, and is no longer relevant to a modern society. This is a man who took an oath to the Constitution. The ranking minority member, Tom Lantos, called the declaration of war frivolous and mischievous, the same way that would happen if you took it before a judge to overrule. They would say this is a frivolous case, and we'll sanction you if you don't stop. At least it was out in the open. Ron Paul said, now surely this display of such disdain for their oath and supporting and defending the Constitution would light up Capitol Hill switchboards with angry colors. Little did he know that no one was watching and no one would be able to watch this open hearing, even though C-SPAN cameras were rolling and congressional tape recordings were rolling. Ron Paul sent his staff member to get copies of C-SPAN tape, having them utter these words so that they could hold their feet to the fire and get copies of the tape recordings. He said, when my staff called C-SPAN, now this is a private organization, not run by government, completely separate from government, to get a copy of the video record, we were told technical difficulties prevented that portion and that portion only of the proceedings from being recorded. And that same portion of the proceedings were also the only part missing from the official congressional tape recordings. Now I ask you, ladies and gentlemen, how do two separate tape recording machines not connected go bad at the very same time? What's the statistical probability of that? It's just in the millions. They were doctored. And the question remains,